avenue that simply wasn't available to them. But to provide some context to this, we have to talk about a woman by the name of Belva Lockwood from 1879. So in 1879, who? Are we going to see a similar progression as to what the NAACP did for America's rights for women? Not really. The ACLU, starting in the 1970s, with the hiring of then Ruth Bader Ginsburg, does sort of tear a path in terms of women's rights, but it's not the slow evolution. The ACLU knew what they were doing. They knew the foundation that they were playing with. And really, in about the time span of 5 years, they carve out women's rights, as opposed to the ACLU's plan that took greater than 20 years. So it's much quicker. So let me talk a little bit about Belva Lockwood. The struggle for women's rights began largely in the 1870s. And so Myra Bradwell was attempting to sort of assert this right. It was an individual level right, but she was attempting to assert it at a broad precedential level. In 1879, Congress passes a law which permits women to argue before the United States Supreme Court, in fact, admitting them to the Supreme Court bar. The person who helped draft that law was Belva Lockwood. So let me tell you a little bit about Belva Lockwood. She was born in Niagara County, New York, eventually became a lawyer, and was admitted to the DC bar in 1873. So she was practicing in DC. After this law was passed, she was admitted to the Supreme Court bar and became the first woman to argue a case before the United States Supreme Court. In 1884 and 1888, she ran for the presidency of the United States as the champion of the Equal Rights Party. Obviously she didn't win, but she actually received votes, which should be notable because she wasn't herself able to vote for herself. The Equal Rights Party began winning exclusively female candidates in 1872. Lockwood was by far the most successful of any of them. What this means is that many men ended up crossing and voting for Belva Lockwood in these candidacies. She worked on a number of issues after 1888. She worked on women's suffrage and represented individuals who were denied their rights in many groups of cases, but in interest to myself, she argued for a period of time before the court about rights of Native Americans, particularly that of the Cherokee tribe. So the United States pretty much allows women to practice in the Supreme Court bar, while many states at the time still exclusively denied these rights within their state. And so this is the foundation. Women gained the right to vote in the 1900s. It helps give women a voice, but thankfully I can cite some precedential research in this area. Women didn't vote at large numbers initially after gaining the right to vote. Why do you think that's the case? And go ahead and type in chat so I can see. Why do you think that women, upon being given the right to vote, did not exercise their franchise, at least in the first few years after they were given the franchise? All right. Well, what I can tell you is there were numerous reasons. One, perhaps some of the reasons for African American suffrage, they weren't permitted by men at home. To a degree, that's right. There wasn't really repression on behalf of the state. There was repression in the homes. Um, they didn't themselves want to exercise it in some cases, most likely. So I recognize all of you are political science. Well, not all of you. Most of you are political science majors. So I make this commentary not about you all, but about your colleagues similarly situated who are not political science majors. We know that voter turnout for individuals between the ages of 18 to 24 is horrible and has always been horrible. So not blaming your generation in any way, shape, or form, but just talking more generally about individuals from ages 18 to 24. The reason why individuals age 18 to 24 don't vote in large numbers, and the reason why women didn't vote in large numbers, at least initially, is because voting is a learned activity. It is one that you engage in the more that it is you engage in it. I know that sounds sort of shocking, but after you do something, hey, now it's time for that water. After you do something, it's easier to continue doing it. So in this regard, women didn't learn to vote. Women didn't vote because it was an activity that they'd never previously engaged in. There were some very politically active women, obviously, and they engaged in voting, but they didn't vote at nearly the same levels. In fact, it wasn't largely until the 70s that we saw a general parity between men and women in terms of voting. So, almost 50 years after women gained the right to vote. Now, what explains individuals of your age, of your generation? I mean, your generation is not atypical from individuals of my generation or of my parents' generation, of your parents' generation. Voting is very much a learned activity. Now, I'm sure there are those of you who, when you turned 18, started voting immediately because voting was something your family did. It was a sort of a learned activity, and you might have gone to the polls with your parents, or politics might have been something you discussed. But for individuals whose families don't vote or aren't engaged in politics, voting is very much something you have to adopt over time. And for women who were exclusively cordoned off from that realm, for the most parts, if not legally, but within their households, voting had to be something that they learned over time. And so why people like Belva Lockwood were out there sort of blazing this path. And Belva Lockwood did get many states to allow women to vote. It wasn't as though women en masse turned out to vote, at least in the short run. And there's some excellent political science work on that, by the way. If you want me to draw your attention to it, in the Blackboard, I can. So the modern women's rights movement, at least in part, does piggyback with the African American civil rights movement. Very much, they see the strategies that the NAACP adopted. They see the legal strategy that they said. Now I'm in the way again. That the NAACP adopted, and they definitely share it. Remember, and we'll always come back to Caroline Products footnote 4, and talk about the court's very, very explicit statement that they were going to protect discrete and insular minorities. And it seems, at least it should theoretically seem, that women are very clearly included in the court's statement going forward. But the problem is we have to question these words, discrete and insular minority. Women were definitely insular, at least politically, but they weren't discrete. And that the problem keeps coming back to this idea of numeracy. Because calling women a minority, at least in terms of numeracy, is not true. But a political minority, absolutely true. And so the court having to battle with that, and the court even coming around to the idea that women were a minority took some time. The court, starting in the 1930s and 40s, starts to move away from Bradwell-type decisions. Understand, like I said, have said before, courts are by their very nature conservative, and I simply mean conservative in that it's slow for them to change. Courts do not change rapidly in terms of jurisprudence in most cases. So while the court starts to move away from the sort of Bradwell decisions of 1873, it goes very, 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 very slowly.